Okay, go.
Good morning, everyone, and welcome to today's webinar, Navigating the New Occupational Health and Safety Act, Key Updates and Implications for Businesses. This event is organized by the Gozo Business Chamber and the Occupational Health and Safety Authority, in collaboration also with Bank of Valletta. Our aim today is to provide businesses with a clear understanding of the recent updates to Malta's occupational health and safety legislation and what these changes mean for employers and employees alike. To begin, I have the pleasure of introducing the President of the Gozo Business Chamber, Mr. Michael Gallia, who will deliver the opening address.
Good morning. It is my pleasure to welcome you all to today's webinar, jointly organized by the Gozo Business Chamber and the Occupational Health and Safety Authority in collaboration with Bank of Valletta. Occupational health and safety is a critical pillar of any modern economy. It is not just a legal requirement, but a moral obligation we all share to ensure that every worker returns home safely at the end of the day. As representatives of the business community, we understand the importance of striking a balance between economic activity and the well-being of our workforce. The recent update to Malta's primary occupational health and safety legislation marks a significant shift in how we approach workplace safety. While it retains key obligations from the previous framework, it also introduces new regulatory measures, a restructured authority, and an impartial tribunal to ensure compliance and accountability. For businesses, especially micro, small, and medium enterprises, these changes bring new responsibilities that require careful understanding and implementation. Today's session will provide us with valuable insights into the implications of these legislative updates. We are honored to have with us experts in the field who will guide us through the key aspects of the new Health and Safety Work Act and answer any questions you may have. To this end, I look forward to the insights that will be provided by Silvio Farrugia, Senior Manager, Policies and Programs at OHSA, and Dr. Melino Mercia, Senior Manager, Prosecution within the same authority. I encourage all of you to actively participate in this discussion and make the most of this opportunity to understand how we can create safer, healthier workspaces for all. Thank you.
Thank you, Michael, for your opening remarks and for highlighting the importance of occupational health and safety in today's working environment. We will now move on to the main presentations of the sessions where we will hear from two experts in the field. May I ask those that are following us that any questions will be answered after the main presentation through a specific Q&A session. So I now introduce Mr. Silvio Mercia, Senior Manager Policies and Programs at the Occupational Health and Safety Authority, and also Dr. Melino Mercia, Senior Manager Prosecution within the same authority. As Michael rightly pointed out, they will provide us through the key updates introduced in the new Health and Safety and Work Act of 2024, explain the new legal obligations, regulatory structures, and enforcement mechanisms. Mr. Farrugia and Dr. Mercia, the floor is yours.
Thank you. Screen okay, please?
Okay.
Okay, thank you. So, thank you once again for accepting us to speak to your group, which is for us at this small community, small business community, is very at heart because we know that you need some form of different approaches to ensure that your statutory obligations are being followed. We understand that while you are not exempt from the law, the approaches by the regulator may need to be slightly different, including maybe more awareness raising sessions that we are doing today. Before I begin, a bit of disclaimer. This is mostly considered an awareness raising initiative. So for specific legal advice, it is always advisable to consult your legal advisor who will guide you in the best options that are available to your specific circumstances. So I will start off with the Act. As many of you may remember, up to November last year, we had a different act regulating this field. It was Chapter 424, and while it was I believe, a groundbreaking act, time has showed us that it needed a bit of an update. There were certain things that we needed to update, including certain developments in our society, Sophia and inquiry, 20 years of experience in EU health and safety practices, new approaches or new challenges in health and safety. So it was high time to update this legislative framework. But those three bullets were the focus of the legislative update. So new risks, a particular psychosocial. Many of you may refer to them as stress or psychosocial well-being. Those have been included in the law and now are given the same importance as the physical risks. It ensures that the authority, as the national regulator, has more effective and efficient surveillance mechanisms, and it allows, therefore, more proactive and preventative measures at a national level. A bit of definitions. I will not bore you with these technicalities. This is, after all, an awareness-raising initiative, but I believe some definitions need to be spelled out and be clear to all participants today. This law is about work. So the legislator defines work as shown on the screen. So any task, duty, activity, whatever a worker is doing while engaged for that employer, while carrying out a service or a task during employment relationship with an employer. But also, and very important, I believe, especially for the goals of business chamber, but it also applies to self-employed. Not only the employer-employee relationship, but this law covers self-employed persons as well. Obviously, there's a definition of a duty holder, which means any person who by law, so under the Health and Safety at Work Act, has some form of duty to fulfill. The most important definition, I believe, is employer. The first one is sufficient. So any person for whom work or a service is being performed by a worker, what we classically refer to as the employer-employee relationship. However, the law act, so I believe I'm referring to the Act 646, also makes two distinctions where there is a contract of services. So the majority of employers are employer-employee relationship are covered with a contract of service. That one means any person having the overall or day-to-day direction. That is the employer. It could be a single person, a group of persons, a group of directors, board of directors, supervisor, foreman, line manager, any person who has a day-to-day management of staff. But there could be circumstances where a company, a factory, a hotel, an office, engages a third-party contractor to carry out works within the premises of that factory. For that engagement, the employer would be the worker of the contractor, unless the factory owner or the factory management gives certain tools, materials, equipment which are defective. So in that case, there are two employers, one having the day-to-day running of the factory workers. The other would have the day-to-day running or operation or direction of the contracting workers. Later on, it will be spelled out, even we can give some examples along the way. Self-employed is, I referred to it already. A worker is any person having a contractual relationship, whether in writing or not, with an employer previously defined. There are some minor exclusions, not because these are excluded from protection, because these groups of workers, for example, the crew of ship, crew of aircraft, they are already covered by other national arrangements, not because the legislator wants to exclude them from protection. They are already covered by like ILO conventions. Let's start with the most, I believe, one of the most important aspects of the law. This act covers all sectors of the economy, covers both public and private, even government workers, all work activities, all self-employed workers. Okay, this is very important for you all. Certain exclusions, I referred to them already, but for obviously common sense purposes, civil protection, police, armed forces, certain tasks carried out intrinsically by certain parts of their activities are excluded from the applicability, 100% applicability of the law. Like, for example, there's a fire. Society expects a fireman to go to put out a fire, but that person putting out the fire may be at a slightly risk of endangering himself. But what can we do? So this exclusion, part exclusion, I'm not saying a full exclusion, only for those specific activity. The last proviso is very important. So even if the fireman goes to extinguish a fire, the head of the fire fighting department still needs to take care of the health and safety of that fireman within the scope of putting out a fire. As rightly so referred to in the introduction, the authority as an entity has been given a clearer role. Now it is clear in the legislation that the authority, the Occupational Health and Safety Authority, or OHSA, is made up of two parts, although being the same authority. The executive, those group of workers, group of the body which executes something, which does or performs specific tasks related mostly to enforcement, and a governance board. Those two together, we call them the authority, but there is a slight distinction between the roles. The governing board is there as an oversight body. It is there, this is very important, not for you individual members, but mostly for the chamber. This body, this board now, gives or makes available, there is within its the structure, a setup to promote health and safety, to give voice to the social partners. So if you have any concern that you wish to discuss, this is the ideal forum to discuss health and safety matters without limiting or your already rights under, for example, MCSD. But this is another option for the social partners to discuss specific themes regarding health and safety at work. There is an element of social dialogue being offered at a national level now. Previously, this was there but it was not that clear. Now it is clear. The functions of the authority. Now, the functions of the executive, I correct myself, are those are those which were already there in the past under chapter 4 to 4. So the implementation of the provisions of the Act, taking enforcement action, monitoring compliance, conducts inspections, promotion, like we are doing, investigation following an accident, a disease, a fatality at work. Those are all the function of the executive. Throughout my presentation, you will see certain red text. The red in my presentation relate to the new or updated aspects. So, keeping register, S6 conduct or conduct prosecution, they're already there, we are continuing doing them. But today, the legislator gave us new powers or new tasks or new functions. For example, we can issue administrative instruments. More on this later. We can impose administrative penalties and special fines. Dr. Merci, I will expand on these. The duties of employer, very short, they are detailed, but I will try to give a summary here. One of the primary obligation of any employer is to ensure the health and safety of all workers. That is, I believe, a very noble duty which society has established. Whoever creates the risk is the same person who needs to address that risk. This, I will not bore you with this one. This is Article 12.2 of the Act. It is the science behind managing health and safety at work. Where are the priorities? The priority would be to avoid, rather than to give personal protective clothing. If there's a problem and you cannot avoid it, identify it, evaluate it, and introduce measures. This is the science behind health and safety at work. After the evaluation stage, the employer should also provide information, instruction, training, and supervision to workers. This is taken from the Framework Directive as well, as the previous obligations. Another important point, employers to ensure that the workers themselves elect or choose or designate their own health and safety representative. The reds are new. Now, every employer needs to draw up, and so it means prepare and review as necessary a health and safety policy statement. The last bullet I will expand a bit, because even during the discussion and the white paper, this was the most part of the law being proposed, which wasn't really that clear. Afterward, it was clarified even through talks, through parliamentary discussions. But still, if there are any of you who are not clear, I will explain it in more detail. The health and safety reporting officer is a high-ranking employee appointed by the employer following the publication of a regulation. So far, you do not need to appoint a health and safety HSRO. I will refer to it as HSRO. Today, you do not need to appoint. You will appoint an HSRO once there will be specific regulations targeted, for example, at a group of employers. It could be blanket, but I very much doubt it will be like that. Or it will be targeted at specific sectors. This is a reporting officer. The reasoning behind it is that where there are serious, consistent breaches. If that is the case, then the authority intervenes and orders or directs specific employers. So far, there are no regulations or there are no specific directions by OSA. So up to today, you don't need to appoint. You only appoint if you are prompted. And the role of the HSRO would be, because there are problems within that enterprise, there needs to be someone who keeps the employer accountable on the actions that need to take to ensure that those problems do not remain. I believe that is the best summary I can give you. But if there are serious problems, then an HSRO will be directed upon you. You need to appoint, and the HSRO would have these functions: to receive and investigate reports, to update the employer on what needs to be done, to keep the employer, to ensure that the employer fulfills these tasks, to provide reports to OHSA, to, for example, keep records. The bolds are important. So, as previously referred, the duty of the employer, the duty to ensure health and safety has been placed on the employer. Appointment of an HSRO does not relieve an employer from those duties. The duty to ensure health and safety at work remains upon the employer. It is the HSRO to ensure that the employer is doing something, is reporting something, is taking action on something. So the employer needs to give the HSRO access to resources, access to information. The employer needs to appoint, but notify us as well that there is an appointment. Obviously, HSRO is protected by law. And failure either to appoint or to follow the HSRO recommendations are both breaches of the law, and they carry the repercussions or the sanction or the penalty contemplated by law that we will hear later on from our lawyer. Self-employed, as I referred to, they are not exempt, and they have been given specific obligations. They are in the law as well. Obviously, the workers have to shoulder their respective responsibilities. And these are spelled out by the law, and the law assigns to the workers specific responsibility to take care of their own health and safety and that of others who may be affected by any acts or omissions by the part of the worker. And the law gives some examples of such actions that is expected from the workers. There's the red text. This is new. One of the new powers of OHSA is administrative instruments. So I give you an example. There is a new technology, for example, there is a new situation in Malta. We need to be fast in addressing it and make some form of legal direction to specific employers. I'm having the GoZo chamber. I'll give a stupid example so that you will understand. There is a new risk only to GoZo. I don't know how come this may come, but let's assume that there's a risk which only affects GoZo and only affects Gozitin factories. The authority, without waiting for a new legislation on the protection of GoZo workers regulations, issues an administrative instrument specifically to GoZo. This is faster, and this instrument or directive or action or direction, call it what you may, but the law says administrative instrument. It will be published by OHSA following ministerial approval. It will be published on the website, and it will become part of our law. Those of you who are familiar with the navigation, with the maritime regulations, there is the notice to mariners that it is a law and you need to follow it. If there's a situation, a storm, a hurricane, and part of the coastline crumbles, they issue a directive, notice to manager, avoid points X, points Y on the chart. And it's mandatory. Similar approach. So far, we have used this once, and we published very recently a new administrative instrument on how persons who deem themselves to be competent to give advice need to be registered. And the new registration mechanisms of competent persons giving advice on health and safety is now covered by Administrative Instrument number 1 of 2025. And it lists the criteria which now have become mandatory that persons giving advice to health and safety must have to be listed on this register. So this is also a more transparent way of doing things. The authority now needs to publish decisions of an administrative covering administrative instruments, so all of you would know where to find them and know that you need what you need to do. This one does no changes from the past except from the title. I will call them the inspectors of the authority so that all of you will understand me. But the correct title would be the Health and Safety at Work officers. These are the, again with inverted commas, the inspectors of the authority who conduct investigatory function, like inspections. And these people, this group this body of inspectors, they have been assigned the power of entry by law. They have a power of entry, and they are issued with a tag, an identification tag, and if they come to your factory, office, or whatever business to conduct an inspection, they have the right to conduct the inspection. They have also the power to issue a direction. The law says order, and I will use that word now. So if you receive an order, you need to obey it. Like stop machinery A, do not use lift B, produce that document within X days. That is an order and it carries a legal weight. So you need to obey it forthwith. And I will repair it. I will, apologies. Okay, I will say it again. You need to obey an order forthwith. But now, the law has given a right, has introduced a right to appeal in front of the tribunal. Previously, the right of appeal was in front of a specific board. Now there is established a tribunal, which Dr. Merci I will explain more in detail. And you can appeal in front of this tribunal. I will not go into much detail because Dr. Melino Merci I will expand more. Officers are public officers under the criminal code, and thus they are protected by law. The legislation obviously has other parts, like the authority can delegate certain tasks, and important for you as well, the debate on the OHSA's annual report of the activities conducted in a previous year are discussed in public in Parliament. So there is also an element of transparency here. I will be concluding soon. The law is, I focus mostly on the act itself. The act, so chapter 646, has a number of subsidiary legislation. These are also, we call them laws, and need to be followed. And I believe one of the most important law, apart from the act itself, is subsidiary legislation 64611. The general, sorry, apologies, I'm a bit sore throat here, which is Legal Notice 36 of 2000, of 2003. And this legislation builds upon the act, but establishes certain other duties. For example, the duty to carry out a risk assessment. Most of you know about it. Gentle reminder, ensure that a risk assessment is carried out, because failure to carry out a risk assessment is an offense in itself. Designate someone competent in health and safety to advise the employer. Consultation of workers. Cooperation when working with other employers. I previously mentioned during the discussion about the duty of the definition of employer, when company A brings a contractor to carry out work within its premises. The fourth bullet takes care of those situations and covers those situations by requiring that whenever more than one worker, one employer, and including self-employed, they are sharing a common place of work, there needs to be effective cooperation and coordination of common health and safety actions. Health and safety of workers is contemplated in Legal Notice 36 2003, 64611 in the new arrangements, and also the protection of vulnerable workers. Other regulations are also important for you, but it depends on the risks that your company is. Obviously, it involves. So that could be have minimum requires of the place of work, the physical upkeep of a place of work, the physical building itself. So ventilation, light, windows, emergency procedure, firefighting, toilets, wash hand basins, things like that. Chemical safety for those who are engaged or use chemicals, asbestos, carcinogens, biological agents, protection for physical agents. For the those acronyms would be so noise, electromagnetic frequencies, vibration, and artificial optical radiation like lasers and 13 bright lights. VDUs would be the visual display units. PPE would be the use of personal protective equipment. Manual handling of loads, signage, specific construction regulations, protection of young persons, protection of maternity, quarries, work equipments, and I mentioned some examples there, and major accidents, not really that important for you, these like the power station in Delimara, these large, huge petroleum storage facilities. I don't believe it applies to this room here. So lifts, hoists, cranes, boilers, escalators, those are all covered by specific legal provisions. So that for my part would be my presentation. I allow now, I invite Mr. Mercia to cover this, but maybe the business chamber may want to make some intervention before.
Thank you very much, Mr. Farrugia. No, your presentation was actually very, very comprehensive in that sense. So I now wait for Dr. Mercia's presentation, which will continue to give us insights on the legal obligations. I think just as a side note, what struck me most is the definition of employer, because many times one may put that function on the owner, or one may discard the responsibility. However, as your definition rightly pointed out, that may be much wider. So the employers need to take note of these developments in order as well to be aware of their responsibility under the law. So to you, to the floor, Dr. Mercia, and for your presentation. Thank you.
Presentation.
Dr. Mercia, we're
Yes,
not.
I'm trying to share the presentation on the screen, but
Yes, we can see it. We can see it.
okay.
But your microphone is far away, or
Can you hear me now?
we cannot hear you well. If you can put your headset on, please. Thank you.
Okay.
Perfect. Thank you.
So basically, my presentation will concentrate on certain issues that are very, very important and are quite new. In this respect, let's start with the composition of the tribunal. For the very first time through CAP 646, we have now a formal structure whereby a person who may feel maybe to contestate or appeal a decision issued from OXA, like for instance an order, stop order, or an improvement notice, or even an administrative instrument, has the opportunity to appeal in front of a tribunal. This tribunal is basically composed of a chairperson and other two members, And the appeal can be either from a decision or an order or even a administrative instrument. Like, for instance, someone might not agree with certain issues that OHSA feels that certain issues may be implemented at work. And it may also hear claims in respect of administrative penalties, because right now we have a specific legislation which addresses breaches which are of administrative nature, and the person who has been sort of fined may appeal the penalty in question. With respect to composition, it's basically there's a chairperson. Chairperson is a warranted legal professional. Relatively, she's a lawyer, and the other two members are one medical doctor and also an architect. So basically, these are appointed for a minimum of 5 years, and appointments are respected in basically for 3 years, but they have to have 5 years experience as warranted professionals. Now, with respect to panels, there's also an opportunity whereby the minister may establish a specific panel. Like, for instance, we have certain cases in respect of a particular hazard, like chemicals or noise or asbestos or even a certain work activity, which may require specific expertise. So in this case, the minister may appoint a specific panel, and this panel will only addresses a specific item or embedded in question. And it's something very important, because sometimes you may find issues that require certain specific expertise, like something of medical nature or technical or structural. So basically, you may need someone that can address the item in question with a particular experience. So basically, if, like, for instance, there's a decision and you want to contest such decision, you can only do so on a point of law. So you have to do so by filing a recourse. It's called an application in front of the Court of Appeal, and within 20 days from the date on which the decision has been served on the person. Again, the appeal is only limited to points of law. So it's about interpretation. It's not about a decision whether you agree with the approach taken by the tribunal. It's only limited to points of law. It's like, for instance, to be clear, it must be about interpretation. Like, for instance, you may feel that the tribunal interpreted a specific provision in the wrong way. Happens. So there's this possibility of appeal. Again, it has to be filed within 20 days on which decision was served on the person, and it's a matter of administrative nature. So basically, it's about civil issues. With respect to administrative penalties, it is important to note that the Health and Safety at Work Act, CAP 646, provides for two types of offenses. There are offenses which are considered of an administrative nature. So basically, these are offenses against the Act, yes, but they are considered of an administrative nature. So they are not categorized under criminal sphere. Like, I mean, they can't fall under prison or a fine or multa. They are only categorized as administrative nature. So basically, they fall under the application of a new legal notice. It's called Health and Safety at Work Procedures in relation to the issuance of administrative penalties. It's basically a new legislation, and it specifies an amount of, let's say, offenses which are categorized as administrative nature. Basically, to put in picture, the failures that are not considered of a criminal offense are only limited to these 5. You have failure to make the necessary filings with OHSA. Like, for instance, you have to file a report or a plan or a notification with respect to certain certification of equipment, or even failure to keep in a form of document. Like, for instance, you have to have a risk assessment in writing and to fail to keep this type of document, or you had to ensure that following an inspection of a specific work equipment was certified, inspected and certified as safe for use, then you have the necessary certification that must be in place. There's also the omission of a required entry in a register. as well as the failure to carry out a risk assessment. So this one is very important because previously under CAP 424, the act which was repeated by the new act, risk assessment was considered as a criminal nature, a breach of a criminal nature. So a person who failed to carry out a risk assessment was instantly taken to court or maybe issued an specific penalty, but which failure to pay it, then proceedings were taken in front of a court of law. And then you also have the failure to appoint a worker health and safety representative. So basically, these 5 matters are considered of administrative nature. So breaches of this type of offenses are only addressed by the health and safety administrative penalties. Then, with respect to issues that do not fall under administrative nature, but first I need to highlight this point. In respect of administrative penalties, the law provides that the breach can be kept at 20,000 euros for each offense. So basically, if you have 5 offenses, you can be fined at a maximum of 20,000 euros. So this is something that might vary from one issue to another. It all depends on the particular hazard that may be present at the place of work, the persons involved, the type of activities. So it's basically varies from one case to another. If, on the other hand, one fails to pay the administrative fine, then it will be considered of something of civil nature. It is an executive title for all the purpose of the COCP, and then basically it all goes down to civil sphere. So it's not about criminal action. On the other hand, in cases where obviously do not fall under the previously 5 mentioned matters, these are considered an offense against the sex. Mainly, someone like, for instance, furnishes false information or produces false documents. It may happen, can happen, and it happened usually. And even, or for instance, willfully refuses to provide the information required. In that case, it might be considered of a criminal offense. There's also, like, for instance, breach like providing incorrect statement, like false information or unlawful refuses to answer questions made by OSA. In that case, it would be considered of an offense against the act. Now, with respect to penalties, this is very important because right now the penalties are quite high. So when you have a case which falls under first conviction, the fine, obviously, when a person is found guilty, declared guilty, can be fined like for a fine of not less than 1,000 euros, but not exceeding 50,000 for every offense. And there's also a risk of imprisonment, which is not more than 2 years. You can have both or one or the other. Thus, in the case of a second or subsequent conviction, the imprisonment will be not less than 1 year and not exceeding 4 years. So it goes like so quite high. And the fine not less than 2,000, but does not exceed 50,000 for every offense. So basically, considering the offenses under the CAP 46 and 424 are quite different. With respect to criminal proceedings, prosecution is proceeded in the front of the Court of Magistrates as a court of criminal judiciary. And with respect to prescription, we have 6 years. We have 6 years prescriptive period from the commission of offense. So basically, we can initiate criminal proceedings from 6 years until 6 years from the commission of offense, which is quite high in respect of a prescriptive period. Now, the other and most important mechanism introduced by CAP 646, which is going to be very quite famous and also used, is called the special compromise procedure. So basically, this is a new mechanism introduced by the legislator, whereby in cases which do not involve fatalities or administrative nature, like offenses which are of administrative nature, may be either proceeded under the front of the Court of Criminal Justice or fall under the special compromise procedure. Now, what does it mean? So basically, we may say, listen, you have an option. either admit and we proceed to the special compromise procedure, whereby we give you a notice. The notice will include the breaches which we might consider that fall under CAP 646, and then you have a specific penalty. Once it is agreed that the person is going to admit and proceed to special compromise procedure, the case would be not proceeded to court of, or even if proceedings have already been going, then it will stop everything. So basically, we will go to the special compromise procedure, and it's like an out-of-court settlement. So once a notice is issued by OSSA, whereby, listen, you can go to the special compromise procedure, or you can either contest it and proceed to court. You have 60 days. The compromise fine is kept in total at 50,000. It all depends of, the hazard involved, the work activity, the persons involved. So a case by case. Once the person accepts to go to the special compromise procedure, it's like considered that you have admitted guilt and also that you're going to pay the compromise fine. So basically, it's totally an out-of-court settlement, which in my opinion serves to ensure justice. You can also limit the load imposed on the courts of law and also ensure that a person has natural justice, there's a fine, you admit your breaches and so settled. So basically, these are new mechanism and new structure introduced by CAP 646, which CAP 424 never even considered. So this is a new mechanism. So the tribunal, the special compromise procedure, and the limitation with respect to administrative penalties are a new mechanism. So it's still need to be seen, but I believe that there's an opportunity to improve justice and also ensure better health and safety standards. There's also an opportunity for a person to appeal, to contest a decision. It's all about transparency, it's all about natural justice. You have all the mechanisms allowed by law, provided by law. So it is a new mechanism which will ensure justice and also improve health and safety standards at work. So basically, these are the most key provisions. I didn't enter into detail. It's quite, you can, organize another presentation, but these are basically the main important salient issues. Maybe you have now any questions from your side?
Now I have some questions in the Q&A. Dr. Mircea.
Yes, sure, okay. You may proceed.
So where can I find administrative instrument number 1 of 2025?
You can also access the legislation from our website or even from the official website, legislation Warsaw. And if you can give me your email address, I will send you the link. And it's not a problem for me.
Put your headset on again, please, because we cannot hear you well. But you can provide it by email, I understand, correct?
Yes, I can
You can write it here if it's possible.
Yes, you can
You
type it in the Q&A section.
Yes, you can access the information either from the official OSTA's website or legislation Malta.
I will paste it on the chat. I will paste the.
No, I'll do it. Don't worry. Any other questions?
So where would the administrative regulations be published?
These have already been published. I will insert the link.
Okay. Can we have a copy of the presentation to be able to communicate with managers and board of directors?
No problem for me.
And can the 60 days be extended?
No. It's not possible, but it's about case by case. There might be certain situations which may merit consideration, like something of medical nature, but it's a case by case basis.
Okay, and the last question we have here is competent person. What does it mean?
Now, under the new regulations, competent person now is required to be registered with OSTA's competent person register list. Basically, we're going to publish a administrative instrument which is going to highlight these details quite in detail, and a person must, besides being competent in health and safety matters, also be registered with OSTA.
So we have more questions about the presentations. Can they be put on the OHSA website? And can we have the presentations emailed to us?
Yes, okay, so no problem. I'm going to upload the health and safety network in English and also Maltese version.
Perfect.
I'll
We
try with
have,
the link first.
we have another question. There are only so much competent persons, so it could be subcontracted.
Yes, yes, might, yes. But the person has to be registered with OSA.
Okay, let me copy this. What are the requirements to be a competent person?
So basically, you have to have certain like experience and also qualifications is going to be published through the administrative instrument, and as well as be obviously experienced in health and safety with respect to proceedings of risk assessment, health and safety plan, and so forth. But these will be published later on through the administrative instrument.
I have another one. Until some time ago, a competent person had to be level 5 or diploma accredited. Can one be registered with the wealth of experience in the field only?
Again, this will be published through the administrative instrument.
Okay, what do I need to do to register with OHSA?
Once the administrative instrument is published, there will be all the necessary details.
Okay. Will an HSRO be required in the construction industry?
Might be, might not. It all depends on the case in question. Like my colleague Mr. Silvio explained, this is something new, and this may apply either with respect to a specific case, specific construction site, or to a specific contractor, or to the specific work activity. So it all depends on the case in question.
Okay, someone is complaining about your sound. Maybe you put your microphone closer, Dr. Mercia.
Yes, it is.
Okay.
If I need to shout more.
I have put on the chat the link to the admissive instrument number 1, where there are the criteria that Dr. Mercia just explained. They are already published on the website, and Dr. Mercia has placed also a link to the legislation itself.
I will distribute this because I don't think that the those registered can see the chat,
Okay, thanks.
but I will distribute it. Okay.
You can access the links, right?
Yes, I will share the links, guys. Okay.
Shall I upload the documents? I mean,
So
with no assistance.
I have
I can do
another
that. I mean, it's not a problem for me.
I have another question. So if company has an outside health and safety officer who is a competent person, the company does need an HSO as well. Is this correct?
Come again.
So if a company has an outside health and safety officer who is a competent person, the company does need an HSO as well. Is this correct?
If there's an order in respect of appointing an HSRO, yes, the employer has to appoint an HSRO, but it must be followed by a specific order by the necessary OHSA. Okay.
Okay.
Just to clarify this HSRO bit, you only appoint an HSRO if there is a specific regulation requiring you to do so, or you receive a direct order, communication, direction from the OHSA. Unless these are two, either of these two are published, you do
don't
not
need it.
need to appoint an HSRO. I believe it is very clear. So only appoint if directed.
So there's another question. Is the NEBOSH certificate considered as an adequate qualification to register as a competent person?
It depends on the level. If the level of the NEBOSH satisfy admin instrument 1, then obviously yes. But if it doesn't fulfill the requirements, no. There is the criteria that you will receive, which are already on the website. They established exactly the minimum qualification required, apart from other aspects.
Man, I think I missed one question by Antoine Sacco. Is it considered that the law considers only OHSA officers as public officers? If so, why?
Femniex, I do not.
Man, is it
Under this act or white across Malta?
I didn't understand the question.
so Antoine Sacco wrote, is it considered that the law considers only OHSA officers as public officers? If so, why?
Why only? Why the focus on only?
I mean, you're referring to officers inspectors, officers
The
officers.
OHSA inspectors, its officers, as Dr. Manager is saying, they are protected by law by being considered public officers. But there could be other public officers out there like other inspectors, police. We're talking about one group of inspectors, the health and safety at work officers. Those are deemed to be public officers and need to be protected. But not in isolation. There are other public officers across Malta.
Okay, Daniel, Daniel, we cannot hear you. You're on mute.
Yes.
Could you
Richard.
please distribute the presentations and these links afterwards
Yes.
to all participants?
Yes, definitely, definitely. Richard, there are some more questions in the Q&A which have just entered now.
Okay. No. Is experience matter instead of qualification for competent person registration?
Sorry. Take a look at the administrative instrument. There needs to be the criteria are varied. It's not a single point entry. You need to fulfill a group of criteria. So not only one instead of two, but you need the whole package to be considered eligible.
Okay, Marina's replying directly to the Antoine Sacco. And
I think we answered all the questions. I mean,
I think we answered them all.
yes,
Okay. So thank you very much. It was a very fruitful session, and we have had a very informative discussion today. And I would like to thank our speakers, Mr. Farrugia and Dr. Mercia, for their expertise and also for addressing our questions. We look forward to continue collaborating with the Occupational Health and Safety Authority on these regulations, on clarifying further importance, further issues that there may be, or any doubts that there may be. I also extend my gratitude to Mr. Michael Gallia, our president, for his opening address, to our partners at the Occupational Health and Safety Authority, and to Bank of Valletta for their support in making this event possible. A special note of thanks goes to Richard Gregg, who was the technical coordinator during this webinar, and for the staff here at the Chamber, Joanne Parnis and Jesmond Buttigieg for their assistance. As we have seen today, occupational health and safety is not just a legal obligation. It is the responsibility we all share in creating safer and healthier workplaces. I hope today's session has provided valuable insights to help businesses navigate these new regulations effectively. And if you have any further clarifications, please feel free to write to us on info@gozobusinesschamber.org. We will be disseminating the links and also any other material that we may deem useful. And if you have any doubts, please write to us and we will direct them to the Occupational Health and Safety Authority. So
I've also listed down my email address. If you need further me to make any questions or clarification or whatever, please free me to email me, don't worry.
We have two more questions. Sorry, can we take them, Daniel?
Yeah, sure.
yes, for sure.
So from Donald Camilleri, so 7 grandfather clause, the 5 years of experience are to be following achievement of the qualification.
I did directly that with Donald. Okay.
Okay, perfect. And Brian Bone, I applied last year to be on the OHSA list, but I'm still waiting for
The
feedback.
same. This is something of a private nature. I mean, I deal with that through email.
Thank you. All right, perfect.
So thank you very much. Let me again thank you, the Occupational Health and Safety Authority, which has accepted to lead this information session, and we look forward to continue collaborating with the OHSA, as we believe health and safety at work are a priority, not only a priority because of the fine or simply a legal obligation, but a social obligation that we must abide to. Thank you, Dr. Merino. Thank you, Silvio. It was very insightful, your presentations, and as I said, we look forward to further collaboration with the OHSA.
Just one last note. I mean, if you have any further queries or you might need more detailed information, please, you have my email address. Email me, don't worry. I will reply, and provide the necessary information.
Thank you. Thank you very much.
You're welcome.
Thanks.
Thank you.